Case number IT 9513AI, the prosecutor versus Slavko Dokmanović.
Let me first verify that the equipment is operative. Can everyone who is using the earphones hear me in a language they understand? Okay. Now, under our procedures, the tribunal records these proceedings, and they are then released to the public. I have issued an order to that effect this morning. This is an initial appearance pursuant to Rule 62 of the Tribunal's Rules of Procedure and Evidence. May I have the appearances for counsel, please? Prosecution.
If Your Honours please, my name is Grant Neiman and I'll be appearing for the prosecution in this matter. My co-counsel, who's not here today, will be Mr. Clint Williamson, and at the bar table I'm assisted by Miss Sutherland.
Thank you, Mr. Neiman. May I have the appearances for the defense, please?
Microphone. Your Honor, my name is Toma Fila. I'm attorney from Belgrade and defense counsel for the accused Slavko Dokmanović. My assistant and legal counsel is Miss Jelena Lopicic.
Mr. Fila, you have been appointed by the tribunal to represent the accused. Is that correct?
Точно.
Yes, Your Honor.
Is the prosecution ready to proceed?
Yes, Your Honor.
Is the defense ready to proceed?
Yes,
Your Honor.
Mr. Fila, have you and Mr. Dokmanović received a copy of the indictment?
Yes.
Yes, we have, and we have understood both.
You read to Mr. Dokmanović the indictment, or has it been read to him in a language that he understands?
It has been read to him, and he understands, Your Honor.
Have you had sufficient time to confer with Mr. Dokmanović?
I did. I had sufficient time. We have consulted, and we are ready for this initial appearance.
Do you believe that Mr. Dokmanović understands the nature of the charges contained in the indictment?
I believe he understands. I have given him a copy of the statute. He has read it through, and he understands what he is charged with, and he's quite ready to make a statement in that connection.
Mr. Dokmanović, would you please rise? For the record, would you state your full name? And what is your date of birth, Mr. Dokmanović?
My name is Slavko Dokmanović. I was born on the 14th of December, 1949.
Have you received a copy of the indictment?
Yes, sir.
I have.
And has it been read to you, or have you read it in a language that you understand?
Pročitao sam.
I have read it, and it has been read to me.
Mr. Fila has been appointed as your counsel to Pardon me? Mr. Fila? Oh, no, I was making just reference to you. Mr. Fila has been appointed as your counsel to represent you in this matter. Are you satisfied with that appointment?
Yes, sir.
I am.
Do you believe that Mr. Fila will represent you effectively before this tribunal?
Verujem.
Yes, I do.
Do you understand the nature of the charges contained in the indictment, Mr. Dokmanović?
Razumem.
I do.
And are you ready to enter a plea with respect to the indictment?
Yes, sir.
I am.
Now, need the indictment be read out in its entirety, Mr. Fila, or will Mr. Dokmanović waive the reading of the indictment in its entirety at this time?
Your Honor, there is no need to read the indictment for me or for Mr. Dokmanović.
Mr. Dokmanović, how do you plead to count 1 in the indictment?
Nisam kriv.
Not guilty.
How do you plead to count 2 of the indictment?
Nisam kriv.
Not guilty.
Do you plead to count 3 of the indictment?
Nisam kriv.
Not guilty.
How do you plead to count 4 of the indictment?
Nisam kriv.
Not guilty.
How do you plead to count 5 of the indictment?
Nisam kriv.
Not guilty.
How do you plead to count 6 of the indictment?
Nisam kriv.
Not guilty.
Fine. Mr. Dokmanović, you will be remanded to the custody of the detention unit of the tribunal until further order of the court. You may be seated. Thank you.
Thank you.
Mr. Fila, have you received a copy of the material that accompanied the indictment?
Ne, nisam.
No, Your Honor, I haven't.
Mr. Neiman, when will you provide the counsel and the defense with a copy of the material that accompanied the indictment when it was confirmed pursuant to Rule 66A of the Rules of Procedure?
Your Honours, we are at the moment just going through the material to ensure that there is no position with respect to witnesses in terms of protective measures, and we would hope to have fully satisfied that requirement within a period of 30 days, and during that period, if it is convenient to the court and is satisfactory to the court, we would make available all of the material that was provided in support of the indictment, and together with what other material that we consider that we will use at trial, which is in a position to be discovered at this stage, if that is satisfactory to the court.
Mr. Fila, under Rule 73 of the Rules of Procedure and Evidence, you are entitled to file preliminary motions, and you are given a period of 60 days to file those motions. Do you anticipate that you will be filing any preliminary motions at this time? And if so, when do you expect that they will be filed?
Microphone, I'm sorry.
Vaša
Your Honor, I have already prepared that motion, but according to the rules, we first have to have the preliminary appearance, and therefore my motion will be submitted to you by Monday. In the meantime, I can review it once again. As for the disclosure of evidence under Rule 66, I think that 30 days is sufficient for other evidence, but I don't see why I need to wait 30 days for what was given to the judge for the confirmation of the indictment. I feel I could have received that straight away. As for the other material, 30 days is acceptable. Have I made myself clear, Your Honor?
You made yourself clear. Mr. Neiman, why do you need 30 days? The rule says as soon as practicable.
As soon as practicable, yeah. Some of the material we can make available almost immediately, but there are just other pieces of supporting material that we, just a matter of precaution, are anxious to check to make sure that, and this may involve checking with the witnesses themselves, to make sure that protective measures aren't required. I mean, in our submission, because of the fact that witness protection issues are of very great concern to the prosecution and indeed to the tribunal, we need to be particularly careful and cautious with respect to material, having regard to experiences that we've had in the past. And for that reason, it takes longer than, and it's not just a matter of bundling up the material and handing it over. That, of course, can be done as a mechanical measure. but then in doing so we haven't made adequate preparation for witness protection should that be necessary.
Obviously have not seen the material that accompanied the indictment, but typically there is a brief that accompanies the indictment as well as statements. But it's not just statements. Is there any reason why you cannot provide immediately to Mr. Fila all of the material that was submitted in support of the indictment when it was confirmed, except for the statements? That should be done today,
Yes.
I would imagine.
Well, we can do that, Your Honour. I'm not sure it can be done today, but we can certainly do it.
Is it possible? Pardon me?
I'm not sure we can do it today, Your Honour.
Why not?
Your Honour, because there was quite a bit of copying involved in doing that, and there's video films and so forth, and I think it would take longer than today.
How long will it take?
I could probably have it ready by Monday, if you want to.
Okay. By Monday, Mr. Fila. Now, with respect to the statements, isn't it possible for you to redact those statements?
It is, but it may not be necessary if protective measures aren't required, and
that's
it
for sure.
may in fact be quicker to hand over statements which we feel are not going to create a problem.
From the defense's point of view, it might be better for you to give the defense the statements, redacting all of the names, and then at the same time proceed to contact these witnesses to determine whether they wish protective measures, and then you would file a motion. The trial chamber would have to be would then act on it.
Well, certainly we can do that in respect of witnesses that we are concerned about. There's no point in redacting where some of the witnesses will probably not create a problem.
Well, then, for those witnesses, can you provide the statements to the defense by Monday, for those for whom there is no problem?
Yes, sure.
So then you will provide all of the material that accompanied the indictment when it was confirmed, except for statements of witnesses for whom you believe there is a problem.
Well, for whom we believe we need to inquire to see whether there is a problem.
Okay. Now, for those for whom you need to inquire to determine whether there is a problem, why can't those statements be redacted? That is, the name of the witness giving the statement, as well as any references in the body of the statements to witnesses. The reason is that, well, there are a number of reasons, but the major reason is that the defense, the period of time allowed to the defense for the filing of preliminary motions is 60 days. If they do not receive the material until 30 days, that's cut into their time. And what I'm going to suggest is that the time period for the filing of preliminary motions begin to run from the date that you receive all of the material, Mr. Fila. But I'm attempting to expedite, if at all possible, the prosecution's providing the defense with the material.
I certainly have no objections to the proposal that Your Honour suggests of extending the time.
Okay. So we will extend the time that that the defense has under Rule 73 to file preliminary motions until the time when you receive all of the material, and then that 60 days would begin to run. However, with respect to the material that you have that accompanied the indictment, except for witnesses for whom you believe there may be a problem regarding protective measures, that should be provided to Mr. Fila by Monday. For the others, if you believe that there are problems, or at least there may be a request for protective measures, I still don't understand why you can't provide that and just and redact the names.
Because it's not as easy as just redacting names, Your Honour.
Well,
there is often material in the body of the
that
statement
would identify. I've
which
seen
tends
many.
to identify, and unless we have an adequate time to go through these and in some instances actually consult the witnesses, we're not entirely sure about what matters contained in the body of the indictment may well go to identification. So it's not a simple process of simply taking a black pen and rubbing out a name. It is more than that. It's a much more complex process than that.
I don't want to be difficult, but perhaps that inquiry should be made when the statements are taken.
Well, they are, Your Honour, but circumstances change. I mean, we don't take statements generally unless witnesses are willing to testify. But but circumstances happen. And I mean, things have been happening on a continual basis in relation to other trials that have been before this tribunal.
Exactly. And some of the things that have been happening are delays in providing the defense with material. And I want to avoid that in this instance. I want to start this. I want to start the proceeding on a good foot. If you understand what I mean, on a good foot.
Yes, sure.
And I want to, as much as possible, encourage the prosecution not to delay in providing the defense with the material. I understand the concerns that you have, but you have to understand the concerns that the defense has. And then, if the material is not provided then promptly, then we encounter problems in terms of setting the trial. And that has occurred. So I want to try and avoid this. I'm not suggesting that you're delaying intentionally. I'm just suggesting a different approach and perhaps understanding the concerns of the defense. Fine. If you understand then where we are, you will receive all of the material that accompanied the indictment by Monday, Mr. Fila, except for statements which the prosecution believes may come from witnesses who may request protective measures. As for those statements, they will be provided to you no later than 30 days from today. And the period of time that you have under Rule 73 to file your preliminary motions will run from the date that you receive all of the material. Is that acceptable, Mr. Fila?
Your Honor, it is a very specific problem that we are dealing with. The territory we are talking about, as the Learned Counsel knows, Croatian authority is being established in the full sense of the word. I already need a visa to enter that area, and I cannot enter it for a number of reasons, including my personal safety. So that people working in Vukovar now of Serbian nationality and who are already affected by the fact that only their names have been published and the method of arrest of Mr. Dokmanović, and we have communicated a great deal, Mr. Niemann and I, so that I'm not insisting on knowing the names of any one of the witnesses that Mr. Niemann will be proposing, not because their safety may be threatened by me or any one of my associates, but for me to know what they are saying and to be able to take advantage of the fact that there are still people in Vukovar who can provide me with certain documents. That is why I'm insisting on promptness. Mr. Niemann knows why I'm insisting on expediency. I'm ready to wait for more than 30 days to know the name of somebody who made a certain statement, but I beg to receive those statements as soon as possible because every day is invaluable. I'm going to Belgrade tomorrow morning to try and obtain material which I assume Mr. Niemann will be referring to accompanying the indictment. And that is why I appeal to you and I insist on receiving the statements as soon as possible. It is the most important thing is not who made the statement, but what will be used from that statement in support of the indictment. The important thing is that I know what they say so that I can provide the defense. I can prepare the defense and the counter-arguments. Thank you for your understanding, Your Honor.
And I gather you may face the same problems with respect to the territory and access to witnesses, etc. Is that not so?
Not necessarily, Your Honor, not in that area.
Okay. Mr. Niemann, I think you get the message. Very, very good. Do as best as you can, but no later than 30 days for everything.
Yes, Your Honor.
Is the prosecution ready to proceed to trial?
Yes, Your Honor.
Is the defense ready to proceed to trial?
Yes.
Yes, Your Honor. Quite prepared.
I'm sure the receipt of the material and subject to the filing of preliminary motions and the resolution of those motions by the trial chamber.
Ako ja to dobijem u roku 30...
If I receive the material within 30 days, I will complete my part within the following 30 days. While my assistants can go there, when they are prevented from going there, then the trial will proceed in an improper way.
Perhaps, Your Honours, because of the unique situation that exists in this particular area and particularly because of the involvement of the United Nations, we will endeavour to make inquiries to see whether or not we can more easily facilitate Mr. Fiela's access to this area.
Thank you, Mr. Newman. So, Mr. Fiela, then you would file, you expect, your preliminary motions, assuming, and I'm sure Mr. Neiman will meet the deadline of 30 days from today, by about September the 8th.
Yes, Your Honor. You will receive my first motion on Monday. That is the one I do not need any material. It has to do with the arrest, the method of arrest, and the guarantees, if they are of any value to the prosecution. The other motions deal with other problems, and I will be able to prepare my preliminary motions by 8th of September. What I'm trying to say is that we are quite prepared for the beginning of trial.
And then, of course, after you file your preliminary motions, if you file them by September the 8th, the prosecution is typically afforded 14 days to respond. I don't know that it's appropriate at this time to set a date for trial because it really would be an artificial date. It would not be a real date. I consider it might be more appropriate to set a status conference that would be after that 14-day period that the prosecution has to respond to preliminary motions to ascertain where the parties are, and then set a trial date after we've had that status conference. May I set a status conference for Monday, September 29th at 10 a.m.? Now, I am concerned, though, that is some distance away, and if the parties have any difficulties in terms of discovery, then Mr. Fiela and Mr. Neiman, you should contact the trial chamber because we are always available and willing to resolve any difficulties, if we can resolve those difficulties, that you may have in the obtaining of evidence. That is at least the material that accompanied the indictment. That's our first concern. And if there are any delays or if there are any other problems that occur, then Mr. Neiman or Mr. Fiela, you should contact the tribunal by contacting the registry indicating that there is a problem and that you need to meet with the judges. And if that is so, then we will be available to meet with you. Is there anything else that we should consider at this time? Mr. Neiman?
Not from the point of view of the prosecution.
Mr. Fiela?
No, as far as defense counsel is concerned. Thank you, Your Honor.
The trial chamber is adjourned.
All rise. Veuillez vous lever.